This is Agriculture Today. We are back now for our agricultural law segment, which as always is covered by Roger McEowen. He is a K-State and Washburn University School of Law professor. So Roger, thanks for joining us.
Good to be with you, Samantha.
Absolutely. We're happy to have you here as well. And today we're covering a story that listeners might hear and they're like, well, what does this have to do with agriculture? But we'll tie it all back in towards the end. But it's the latest information that's been released from the administration on forgiving student loans in the country. So tell us a little bit of background on this and what we should expect.
Yeah, that's right. As just about everybody has heard, the administration has announced that it would cancel or will be canceling up to about $20,000 in student debt for Pell Grant recipients and up to $10,000 in student loans for those that make under $125,000 a year. Now, that's double that amount for a married filing joint return. The cost of this is projected to be in excess of $300 billion.
Wow. Yeah, when you hear that 300 billion number, it's hard for me to even grasp how much money that actually is. And the question really is now is this constitutional, right? Because this case will be really the first testing the Supreme Court's ruling on that ruling West Virginia versus the EPA that we covered not too long ago. Is that correct?
Yeah, that's how I read the administration here is using a post 9/11 law, the Higher Education Relief Opportunities for Students Act, or HEROES Act, to justify what they're doing. And that act gave the Education Secretary authority to waive rules related to student financial aid programs when there's a war or national emergency. And so what the administration is saying here is because COVID was declared a national emergency, the administration claims that forgiveness of student debt allows the borrowers to not be placed in a worse position financially as a result of the COVID emergency.
I guess that's my question here is when it comes to declaring a national emergency, do they have a fine start and stop date, or is it just something that kind of dissipates like we've seen with COVID over time?
Yeah, well, 22 is a lot different than August of 2020 when it comes to COVID.
Absolutely.
Is COVID still a national emergency now that justifies the action? I would say that it's pretty clear that no, August of 2022 is nowhere near the situation of August of 2020. I think it's really a big stretch to suggest that the world of COVID in August of 2022 is anything like the world of post 9/11 that they're basing their power on because of the HEROES Act that was enacted because of that. And even if it is an emergency, the question is whether, even if it is an emergency, is that enough? Post the SCOTUS opinion of late June in West Virginia against EPA, as you referenced, I'm not convinced that it is. It may fit the text of the statute, but now the Supreme Court has said that's only the first step. You have to clear what's known now as this major questions hurdle.
Just to recap back on that West Virginia versus EPA case, that was considered a huge win for agriculture, right? Because it helped kind of put control on a lot of those regulatory agencies, and that not only attests to those certain circumstances, but also in the circumstances that we're seeing now play out, correct?
Put it this way, agriculture is very heavily regulated at both the federal as well as the state level. And in that West Virginia against EPA opinion, the Supreme Court really curtailed the EPA's authority to regulate greenhouse gas emissions at coal-fired plants without express congressional authority under what's known as the Major Questions Doctrine. They have to have a specific grant of authority if you're going to really change the manner in which energy is produced in this country by regulation. They said, no, that requires Congress to clearly delineate in statute how you go about doing that. So what that tells me is that congressional authority is now necessary before the executive branch and the agencies of the executive branch take major actions that will have large economic and political significance. And a $300 billion price tag certainly is large economic significance, I would think, under that West Virginia EPA case. And as you said, that was a huge, agriculture, a big win for agriculture on issues such as wetlands, what the WOTUS rule is, and anytime you have other conflicts with federal government regulatory agencies that basically are policies being implemented at the agency level rather than being set by the Congress.
Oh, you've mentioned before the doctrine being really questioned at this point.
Yeah, clearly the Congress can do what the administration has done here. I don't think there's any question that the Congress can do it. They can pass it. the question is whether the executive branch can do it without the Congress, and that's where the rub is. And the administration's already lost cases where it claimed to have emergency power. You think about their attempts to get a vaccine mandate, the tenant eviction moratorium. Both of those were struck down by the court, saying you don't have the power to do this unilaterally. So the question is whether they can, again, is this a legislative function or is it a regulatory function by the executive branch? Now, before this can be challenged, a lawsuit can only be brought if the party bringing the suit can prove that they have been harmed. That's known as standing. So who has standing in this instance? Well, the Obamacare saga teaches us that the U.S. House of Representatives would in this instance, but as currently constituted, they're not going to bring a suit, only if it politically changes hands this fall, and then we have to wait until a new Congress is seated in January before they would be able to bring a suit. Well, if you want to move quicker than that, private banks or loan servicers that have a direct or indirect relationship to the loans would have standing because they have harm. So once you clear that hurdle, and I think you can clear that hurdle in this instance, there's a debate, granted, there's a debate among legals, and I think the weight of the authority is on the side that there would be standing in those two parties.
Absolutely. And you mentioned the timeline of both of those. So it's either private bank comes forward sometime soon or relatively soon in the grand scheme of things, or we find out after our latest election season and into the new year. But even if that changeover happens and there is standing that is occurring, it's going to be a long timeline for this to actually be figured out. Is that correct?
Yeah, I've gotten this question already, and that is, okay, so what happens if a lawsuit's filed? And, well, nothing can happen until the administration finalizes the policy. You can't just make an announcement and then the next day apply for loan forgiveness. No, there has to be a process where the administration would finalize the policy. Then once that happens, the court could be asked to issue an injunction, and I could see some banks that have standing asking a court to, hey, wait a minute, let's stop this till the courts settle the constitutional issue that's involved. And that would force the administration to either extend its current repayment pause or have borrowers start repaying loans that might later then be canceled. And all of this might actually cause the administration to more fully explain how COVID fits the purpose of the HEROES Act and better detail the legislative history of the statute to justify their current plan, or try to fit, as an alternative, they could try to fit it under the Higher Education Act of 1965. Really, I think that's where this fits, because that's really the real reason for the action, purportedly to expand access to higher education.
I think the key that a lot of people are forgetting about at this point is that debt forgiveness is normally taxable, correct?
Sure is, yeah. It's canceled unless it's credit card debt or student loan debt, except for this. Normally it's taxable, but this would not be taxable under a provision enacted last year in the American Recovery Plan Act, as long as it occurs before 2026. So through 2025, this debt would not be taxable at the federal level. And that's not the case in all the states, because not all of the states couple with the feds on tax policy. They don't adopt the Internal Revenue Code wholesale. And so it would be taxable, according to my count, in 13 states. Kansas is not one of those states, but it would be taxable in 13 states. And so normally debt cancellation is taxable. Even if you're a farmer and you file Chapter 12 bankruptcy and you have some of your debt written down, forgiven, canceled, that's taxable. Now in a Chapter 12, what we can do is we can move IRS to the back of the line. We can deprioritize those taxes. But the normal rule is that, yes, forgiven debt is taxable.
And because this debt isn't, however, is that some added cost that we should anticipate because of this forgiveness plan?
Well, the forgiveness of the indebtedness on these student loans would add another $34 billion in lost tax revenue. So you've got the upfront cost of forgiving the loan, or $300 billion. Then you throw in another $34 billion in lost tax revenue, and you put those together. And I think that goes back to our major questions issue. This is a major policy change. It has tremendous impact on the Treasury, and probably, in my view, and there are arguments to the contrary, but I think those are the weaker arguments. I think this, according to the way the court has read the major questions doctrine, I think this would trigger it, and ultimately, I think the court, as currently constituted, would strike this administrative action down.
Wow. Well, Roger, as always, I will link to your blog in the show notes of today's program. So that way, once you have this article up and ready to go for listeners, if they're looking for more information, they can go and click and look at that. But Roger, as always, thank you so much for your time today.
Thank you, Samantha.
Absolutely. Once again, that was Roger McEowen. He is a K-State and Washburn University School of Law professor, providing our latest agricultural law update.